Our last case on the docket is State versus Cory Helmstead, number 127667. Counsel, thank you for rearranging your day today to be here this morning instead of this afternoon. We appreciate it.
Absolutely.
Okay, appearances, please.
May it please the court, James Latta of the Appellate Defender's Office, representing Cory Helmstead, and Judge Gardner, may I please have 3 minutes for rebuttal?
Yes, you may.
Thank you.
The state of Kansas appellee appears by Sierra Logan, Assistant Reno County DA.
Thank you. You may begin when you're ready.
Again, Your Honors, may it please the court. I'm going to cover I'm going to highlight some topics really briefly, and then I invite Your Honors to ask any questions as soon as you have any, if you have any. For my first issue, for insufficiency of the evidence, I just want to remind this court that we're in de novo standard of review, not the normal standard of review where we say, can a rational fact, could they have found something? So I actually have that finally going for me for this issue. And then
let me ask you about that issue.
Sure.
If this was submitted to the bench on stipulated facts, correct?
Yes, Your Honor.
And when I look at those stipulations of fact, this one jumps out to me. It says, the evidence in this case is sufficient for this court to find Helmstead guilty as charged of, and then it lists the 3 things he was charged with.
Sure.
How can we get around that? How do we get past that? What do we do to find error on the part of the district court in saying, okay, that's sufficient evidence?
Sure, I got a few reasons, and I'm going to try to circle back to the first one.
Okay.
So my first one would be the state never raised it, which harms me a lot.
But we're reviewing de novo. So we're looking at those stipulations of fact, and that's one of them.
Right, and so my second point would be that the parties cannot stipulate to an erroneous conclusion of law. So the whole point of a bench trial is to find guilt or innocence. And so in any bench trial, you cannot stipulate to that conclusion of law. And my best case for that would be State v. Stoll. That's the case where the defendants, they also had a bench trial, and they stipulated that the defendant was, they had to register for Cory as a matter of law. And this court actually applied the invited error rule, saying that they invited it and they're stuck with that now. And then the Kansas Supreme Court granted review and said, no, you can't stipulate to these erroneous conclusions of law. We have to review it ourselves and determine whether or not that was correct. So that's my second point there. The third
So you're
point,
saying that he couldn't have stipulated to say THC equals marijuana, or less than, no showing of percentage of THC. So is that, I mean,
that
so
is my,
basically that's
right,
okay.
as a legal matter, they cannot stipulate that as a matter of law, marijuana is THC.
Right.
Because the statutes, as I point out in the Franklin case, say that's not true. My third point why I don't think you should rely on that stipulation is they have a right under the due process clause from way back from Winship that says every conviction must be proven beyond a reasonable doubt. So were Cory to waive that, he would have to do a knowing waiver. And there's no knowing waiver of the right to be found against conviction. He waived his jury trial, but not to be found guilty. This wasn't a plea. I mean, if we allow these types of stipulations, we're basically entering into plea territory. And so because there was no knowing waiver, this court should also disregard that stipulation. And then the final reason why this court should disregard that stipulation is, even if we want to go into the realm of where we say there is some kind of error, like we do for an element for jury trials, and we get into constitutional harmless error, well, in this case, the state never argued against it, so I can come back around to the front. So still, they would lose on harmless error because that'd be constitutional error, and they can't meet their burden if they don't argue it. But even if they did, in this case, they would lose that burden, because this is not like the cases where we have the state submitting a journal entry showing that the defendant actually had a prior conviction for a felony that matched, when they waived the element on the possession of a criminal weapon cases. So they wouldn't be able to meet their harmless error, because in this case, the evidence was that this substance was THC. And I want to be clear, the evidence in this case wasn't like we see in marijuana cases, and that they kind of talked about in the Brown case that came out on Friday. This wasn't a case where we say we have a substance, and in that substance, we found THC, and because we found THC in that substance, we think the substance is marijuana. This is a case where all the evidence, including in the stipulated facts, was that the substance was THC. And so as we know from the Franklin case and from the statutes, that those are two different substances. And for that reason, you know, and I also want to point out in the Franklin case, they talk about this kind of bait and switch tactic that they were worried about. And that's almost kind of what's happening here in this appeal. Because in issue 1, the state wants your honors to uphold the conviction saying that it's marijuana. And then if you go read issue 2, the state's saying, well, you need to uphold this conviction because we proved that he was using THC. So they want to have it both ways in each issue. And that's what the Franklin court was kind of cautioning about.
Well, it just seems like the district court didn't have a chance to look at any of these things. I mean, the stipulations don't really set up the THC versus marijuana issue. And here we are in appeal having to decide them in the matter of first instance. It's not quite our typical insufficient evidence type of a case, which obviously doesn't have to be preserved. It's a weird deal.
Right. And I would also point out that they incorporated all the testimony from the preliminary hearing and the suppression hearing into the stipulated facts. And when I went back and was rereading those yesterday, it was clear that the officer believed the substance to be THC, not marijuana. And obviously, I mean, the officer didn't even have the capability of testing to see whether or not, you know, like the KBI, to see whether there's some ingredient in there that makes it marijuana. I mean, and then I also just want to highlight that this is a brown wax we're talking about. You know, the marijuana definition talks about a plant. There's no evidence of green vegetative substance. I mean, that's also in the stipulated facts that this is a brown wax that the officer believed to be THC as soon as he saw it, that from the vape pen would heat up and burn just from the heat alone, not something they have to put a flame to actually make it burn like marijuana. And so when you consider all that, I mean, this is really where they just charged the wrong crime. Rather than, and they charged the wrong crime that didn't match the evidence. And so based on that, that's, you know, it's not the same where I'm just saying this evidence, I'm asking this court to reweigh the evidence. Even if the standard review was against me, I still think I would win in this case. But unless your honors have any questions on that issue, I think I'd briefly talk about issue 2 and the Brown opinion that came out last week, the Kansas Supreme Court, where that was a tough read for a Friday afternoon, where they said there's no the state doesn't have to disprove exceptions to marijuana, which I'm sure hurts me when I'm saying the state has to disprove exceptions to THC in issue 2. So my best argument to get around that would be that in the definition of drug paraphernalia, as I point out in my brief, it talks about it has to be in violation of this act. And so the best argument that I have to get around Brown is that the statute itself makes the state have to prove, by using the phrase "and in violation of this act," has to make it prove that it's the illegal form of THC, that it has more THC than 0.3%. So in this case, it would be different than Brown because we have that extra statutory element that would change it. That would be my best argument to distinguish Brown from this case. And unless your honors have any questions, that's all I have.
Very good. Thank you for your argument.
Thank you.
May it please the court. This case, as the court has spoken about, was resolved by stipulation of facts. Those stipulation of facts were agreed on by both the state and the defense. These were presented to the district court, who accepted those stipulations and making a finding of guilty. The stipulations included possession of marijuana. That brings us to what is the definitions, which are included in 2157.01, where the definition of marijuana in subsection K says means all parts of all varieties of the plant cannabis, whether growing or not, and resin extracted from any part of the plant, and every compound, manufacture, salt derivative, mixture, or preparation of the plant and its seeds or resin. As is well common knowledge to the entire country at this point, THC is the active component in marijuana.
But how do we get around, counsel, the fact that THC is contained in a separate statutory subsection than marijuana? I mean, how do you distinguish this from Franklin?
I'm not trying to say that I shouldn't have charged it under the THC statute. However, I think the definition of marijuana is inclusive into the fact that you can infer at that point that THC, being the active component of marijuana, would be considered marijuana. It is a substance that is extracted from the plants. Yes, there is a separate definition for the cannabinoids. I always say it wrong. And ultimately, you know, we're dealing with the same underlying substance in the fact that we are dealing with THC. It's a part of both. It's how we get THC is from marijuana. Granted, there is a separate section in the statute for it, and if I'm wrong, I'm wrong. I'm not unwilling to admit that, but I think there is a point here that it didn't go in front of a jury. It went in front of a judge, and a judge who has been an attorney for decades and is a rational fact finder at that point, who had heard the motion to suppress arguments and determined that there was no violations, and knew the facts of the case and what was going on, and had seen the KBI forensic laboratory report. This is a judge who reviewed the stipulation of facts and found that they were reasonable.
Let's talk about the stipulation for a second.
Yes, ma'am.
Okay, so when I read this, there are 3 paragraphs that jump out to me because it just seems that they might be in conflict, or at least may be ambiguous. So in paragraph 3, that's where at the last sentence, the defendant specifically reserves his right to appeal the court's denial of the motion to suppress. So we have that promise. And then in 7, there's a statement, the evidence in this case is sufficient for this court to define the defendant guilty, etc. But then what's giving me heartburn is in 9. The stipulation to the above paragraphs does not waive the defendant's, Cory Helmstead, right to appeal the conviction, which is a really general statement. And so how do we interpret 3, 7, and 9 together?
Absolutely. So this case went before the district court after a prelim. They raised their motion to suppress arguments. After the denial, what occurs not super often, but on occasion, is that to expedite essentially the process from motion to suppress denial to post-conviction is a bench trial on stipulated facts. So the intent of the parties at this point was that we're seeking resolution for defense to go ahead and appeal specifically the denial of the motion to suppress, because they do not have the opportunity to appeal prior to conviction. So in looking at 3, that is the defense assertion that they are wanting to appeal that decision. And then in paragraph 7, they're saying, yes, we're appealing the decision of the motion to suppress. For the purposes of that, we are agreeing that the state has evidence that could find the defendant guilty. So we want to appeal this. We see the evidence is here. Sorry, I'm using my hands. I apologize. We have they're agreeing that, yes, there is evidence that would support these convictions. We are just wanting to appeal because the motion didn't necessarily argue about whether or not it was marijuana or THC. It was whether or not it was Miranda violations, which is a whole separate issue.
What violations?
Miranda.
Oh, okay. I've heard of that.
So have I, just once or twice. So it wasn't that they were concerned with the substance at that time. It was whether or not statements that were made by the defendant were voluntary. He had made some pre-Miranda statements and then waived Miranda to speak to the deputy. That was the issue that they were concerned with appealing at the time. So I don't...
So it looks like that you could read these stipulations that he preserves his right to appeal the motion to suppress.
That's correct.
But not the sufficiency of the evidence that we're looking at now.
that wasn't the intent of the parties, no. The intent of the parties was that they raised that motion to suppress on the Miranda violation, and whether or not the statements, the voluntary statements that he made pre-Miranda, and appealing the district court's decision on that. And that's laid out in issue 4, where Judge Schroeder went through numerous cases and factors that needed to be considered and laid them out in great detail on what he was considering for each factor in determining whether or not they were voluntary, ultimately deciding that at the time of the pre-Miranda statements, they were voluntary. He was not in custody for the purposes of Miranda. So the appeal came from a possible Miranda violation, not a violation of a sufficiency of the evidence, and that is where we get.
And how are we to glean that intent, though? Because, I mean, we see what the stipulation says, and then I look at the transcript, and, I mean, the judge says, you know, based on the stipulation of fact, I'll find the defendant guilty. Understanding that he's preserved his right to appeal, correct? State says that's correct. Court says make sure that's on the record. It's also included in the stipulation. So there's not, I mean, it doesn't clearly tell us, yes, he's preserved his right to appeal the motion to suppress.
And that's where we come in with, I think it was paragraph 3, specifically stating that the defendant is reserving his right to appeal the court's denial of his motion to suppress.
But then the final 9 could have simply said that as well. Like, why in 9 does it change and say appeal the conviction?
And to be quite frank, I drafted these quite some time ago, and I could not tell you why I left both paragraphs in. I can tell you from this case, I was the charging prosecutor on that case. I handled every hearing. The intent of the parties was the appeal of the motion to suppress. That was our intent at the time.
So we haven't really gotten into then the Miranda issue. I don't know where we're at on time, but.
So the Miranda issue was litigated extensively. We had, I believe, and it was an entire day hearing in front of Judge Schroeder, where the deputy, in this case, Mikkel Boehringer of the Reno County Sheriff's Office, had initiated a traffic stop on a vehicle for some relatively minor traffic violations that quickly changed into a DUI investigation. The defendant, in this case, Cory Helmstead, was actually a backseat passenger in that vehicle. He was not detained for any period. Initially, when the car stopped, if he wanted to leave, he could have left. That is what the deputy testified to. Up until the moment when he was getting out of the vehicle so the officer could search the vehicle post-arrest on the driver named Jonathan Bonnet. He arrested him for DUI and then was going to search the vehicle for fruits of that DUI, which is perfectly lawful. Well, when Mr. Helmstead goes to step out of the vehicle, he knocks over an open container of alcohol, specifically a Coors Light can, which is identified as a alcoholic beverage. There's a brief statement made when the officer is searching the back seat of the vehicle. He kind of utters to himself, Mr. Helmstead does, about everything in the back seat is mine, which piqued the deputy's interest at that point. So he sees that he hears that statement and pulls out this vape pen and says, "This is yours." And he says, "Yeah," or "Yes," whatever he says. It's something of an affirmation type. And at that point, the officer concludes his search of the vehicle. He then has Mr. Helmstead step off to the side to read him his Miranda rights and talk to him if possible. So at the statements pre-Miranda, he was detained at that point for the investigation because he was seen knocking over an alcoholic container that he had in his possession at the time that the vehicle was moving. He claims all of those without being asked any questions by the officer, and then when further investigation leads to the possession of the THC vape pen, leads the officer to reading him his Miranda rights, where he then makes a knowing and voluntary waiver of those rights and answers the officer's questions. And Judge Schroeder of the district court went through at length the factors that he considered, and those are all cited in the state's brief, of walking through each of those cases and each of those factors listed out. And it got a little confusing in the transcript because he kind of jumped back and forth a little bit. I tried my best to delineate those in my brief as best I could of the analysis that we walked through that day, and determining that he was not in custody for the purposes of Miranda, made voluntary statements without being asked, was one single follow-up question of, you said everything in the backseat was yours. Is that this too? Because it was found in that backseat pocket. And then moving into a Miranda investigation. And ultimately, one of the biggest factors I think here is that he wasn't arrested for these crimes at the time. These are misdemeanor offenses. He very well could have been arrested, but the deputy said, I'm going to long form you, which in Reno County just means we'll send up charges to the DA's office afterwards, and they'll determine whether or not you're going to be charged. So at that point, he's released from the scene. There's a front seat passenger who was the, I believe, significant other of the driver, who had gotten out of the vehicle a couple of times, had asked if she could leave, wanted to take the car, but the officer said, not yet, you can't, because I got to search it. So there was a lot of movement around. This wasn't a situation where Mr. Helmstead was placed on the curb and handcuffed, said, I'm doing a search of this car, you can't leave until everything is completed. It was, if he wanted to get out while the officer was doing his DUI investigation, there's a couple other officers on scene, and it would have been, okay, let me see if you're allowed to leave. And if, at that point, he would have been allowed to leave. The deputy testifies to that. So he wasn't in custody at all until after he was asked to step out of the vehicle, because he remained in the car that entire time. But had he asked to leave, he would have been free to leave up until the point where he is observed violating the law of transporting an open container of alcohol in a moving vehicle. So no violation of Miranda. And if regarding the open container, we briefed that issue. And as to the paraphernalia, whether or not the state's not trying to bait and switch or have it both ways. Drug paraphernalia is clearly defined. Vape pens are smoking devices. No one is allowed to possess THC, waxy substances here in the state of Kansas. It is a violation of Kansas law, so that's clearly a violation of the act.
But only if it's above a certain percentage, correct?
Right, but that sort of material, to my knowledge, at the very least, is not what is used in THC vape pens. Like what qualifies under the Hemp Act would be, I don't believe they put that in vape pens. I would have to talk to the KBI about that. But to what we have here is strictly THC in a vape pen, and that is what we're arguing is considered drug paraphernalia per the statute. So, does the panel have any additional questions? Okay, thank you.
Thank you, counsel. Mr. Latta, you have 3 minutes.
Thank you, Your Honor. I don't think I have anything to add unless this court has any questions.
I think we're good. Okay.
All right.
Thank you,
Your
both.
Honor.
Thank you both for your arguments. We appreciate it, and we'll get you a written decision when we can.
Thank you.